Welcome everyone. Today is Monday, August 10th, 2020. This is the meeting of the Planning Board. And Barbara, can we get started?
Yes, let's call the meeting to order. The following meeting has been conducted by electronic means in accordance with the Open Public Meetings Act, Chapter 231, Public Law 1975, amended 2020, which explicitly permits a public body to conduct meetings electronically during a state of emergency. Adequate notice of this meeting have been provided to the Coaster and the Asbury Park Press. All notices are on file with the board secretary. In addition, a notice regarding the virtual meeting and instructions are published in the Asbury Park Press and the City of Asbury Park website. Copy of the notice is on file with the board secretary. The notices and conduct of this meeting are in accordance with the guidelines for virtual meetings issued by the New Jersey Department of Community Affairs. Please note that all microphones of public users are muted until the public question or comment period. If you'd like to speak during that time only, be sure to raise hand. Use the raise hand button in Zoom if on a computer, or dial *9 if on the telephone. Your name or last 4 digits of your phone number will be called when it is your turn to speak. If at any time during your question you are deemed to be out of line or topic, we reserve the right to mute your microphone and will make an announcement that this has occurred. During the public comment session only, the public will have 3 minutes to speak. Please turn off all cell phones and electronic devices during the meeting. Please identify yourself before you speak at all times. And this meeting is being recorded and will be available to view via APTV. Please join me in the salute of the flag. I pledge allegiance
To
the flag
of
of the United States of America and to the republic
for which
which
it
stands,
stands,
one nation, under God, indivisible, with liberty and justice for all.
Okay, thank you. I will take roll now. Mayor John Moore,
Here.
Councilwoman Yvonne Clayton,
Here.
Michael Manzella,
Here.
Jim Henry. I think he's muted, but
He was here.
and you need to unmute.
okay. Jim Henry. Yep, we got him. Okay, thank you, Jim. Jennifer Souter.
Here.
Trudy Sysak is absent. Alexis Taylor.
Here.
Eric Gallipo.
Here.
Rick Lambert.
Here.
And Barbara Krisak.
Here.
Thank you, everyone.
The first item on the agenda is the approval of minutes from the June 1st, 2020 regular meeting. Did anybody have any concerns about those minutes before I ask for a motion? Okay. All right. Can I get a motion to approve the minutes of the meeting of June 1st, 2020?
Move to approve. Jim Henry.
I'll second it, Barbara Krizak.
I have a motion by Jim Henry and a second by Barbara Krisak. Let's see. I think everyone is eligible to vote.
I'm not.
Oops, sorry.
I wasn't present at that meeting.
Okay.
Moore cannot vote.
Councilwoman Yvonne Clayton will be recused. All else, everyone else in favor, say aye.
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 Any
Aye.
opposed? Thank you. Minutes approved.
All right. The
I'm
next
sorry.
item.
Moore could not vote. I was not there.
Oh, that's right. John was the one that was not there.
John and Yvonne both.
John and Yvonne. Oh,
Eric.
thank you. John, Yvonne, Eric, and Trudy. Sorry. Let's try that again. So John, Councilwoman Clayton, Eric Gallipo, and Trudy Sysak are ineligible to vote for these minutes. I have a motion by Jim Henry and a second by Barbara Krisak. Everyone else who is eligible, please say aye.
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 Thank you. Any opposed? Thank you. Minutes approved.
All right, the second item on the agenda are the minutes from the July 27th meeting. It's a regular meeting that we had. Does anyone have any concerns about those minutes or need any changes to be made?
Jim Henry, yes, I do. On page 3, about a third of the way down, I asked Mr. Curley about the addition of another, it should be 50,000, not 50 cubic feet.
50,000 cubic feet, is that the change? Okay, thank you, Mr. Henry.
And this is Jen Souter. On the first page where it says Souter, and then it says Alonzo, the first 2 words there say customized neighborhood. I don't think that was the word that was used. I don't remember what the word was, but when she said customized neighborhood, I'm not sure what that meant there. Does anyone remember?
I'm sure that was probably a typo, so I will go back to the minutes and correct that on page 1.
Thank you.
Jennifer Souter, in reference to Michelle Alonso's comment.
Thank you.
Thank you, Jennifer.
Anyone else? If no one else, can I get a motion to approve the minutes of July 27th?
Move to approve. This is Clayton.
Second, this is Rick.
Thank you. I have a motion by Yvonne Clayton and a second by Rick Lambert. And everyone beside Barbara Krizak is eligible to vote. All in favor, say aye.
Aye.
Thank you. Any opposed? Minutes approved. Thank you.
All right, the next item that we have up is a resolution for the STARS redevelopment plan amendment. We have the modifications that we'd requested from Michelle to make them. And one thing that I would like to mention for some of the folks that are on the phone is that there was some concern about the lighting modifications, or that there was an actual ordinance having to do with lighting. And there was some concern that, you know, sometimes things don't happen when we really, when we think that they are. And what's happening is that with where we say landscaping and lighting objectives and requirements, we specifically state in the modifications and STARS that that they shall comply with section 30-63 of the Land Development Ordinance of the City of Asbury Park. That ordinance is in front of the council this Wednesday. So it's a happening thing. So if anybody has any concerns or comments about lighting around the city, they should come to the Wednesday meeting of the council and voice their opinion there, because that's where it's being presented. So it is a happening thing.
Hey,
Anybody?
Barbara, John Moore here. It's the ordinance. It's not an ordinance for public participation. It's a resolution to pass it to the planning board. So if anybody wants to talk about it, they can talk about it during their 3 minutes before the meeting. So there is no public participation on the resolution passing it to the planning board.
Okay, thank you. Thanks for the clarification. Does anyone have any concerns about the resolution as it was written? Okay, can I get a motion for approval of that resolution?
So moved, Mike Manzella.
I'll second that.
Okay, I have a motion by Michael Manzella and a second by Barbara Krizak. And everyone except John Moore is eligible to vote on this resolution. All in favor say aye.
Aye.
Any opposed? Thank you. Resolution memorialized.
Okay. The next item on the agenda is the AP Triangle, the 2 applications. At this point, I will recuse myself and turn it over to Rick Lambert as acting chair for this application.
Thank you, Barbara. This is Rick Lambert. So before we move forward, I just have a brief recap of kind of where we are. So at the last meeting, there was a lot of concern with the stormwater management plan, and the planning board's belief that we had some jurisdictional ability to ask for some additional mitigation measures. At that time, this was based on some informal conversations between the board engineer and DEP. So we asked for clarification from the DEP, and which we got correspondence back from Chris Jones, who really didn't give us much guidance as to whether or not we had jurisdictional ability to impart any additional mitigation measures. So Jack Serpico, the board attorney, reached out to the Redevelopment Council to get an opinion as to what our rights were with regard to this issue. And the opinion of Mr. Marizzetti was that we do not have parallel jurisdiction to impart any additional mitigation measures, and that the stormwater management plan that has been submitted by the applicant in compliance with CAFRA permit is sufficient to meet the stormwater management needs of this development site. That being said, now we can move forward with the remainder of the meeting, which I believe is going to be cross-examination of Mr. Curley based on testimony from the last meeting.
That's correct.
In light of this recent correspondence, there may not be very much cross-examination that's required. But so I will turn it over to you, Jennifer.
Yes, good evening, board. Thank you, Ms. Lambert. I think that you characterized the correspondence from DEP and the letter from Redevelopment Council consistently with our interpretation as both of those documents as well. And we're here this evening, as you indicated, to finish the testimony of Mr. Curley by opening him up to cross-examination and also opening him up to any questions from the public, and then presenting our closing statement and allowing for public comment, and hopefully wrapping up this application so that we can all move forward.
Yes. Thank you for your patience for allowing us to explore all the options that we thought we had at our disposal. We wouldn't be doing our job if we didn't try to, explore every option that we could possibly have. So I appreciate the applicant's patience.
Thank you. Thank you. So I'd like to have Mr. Curley, I don't know if he's
I don't see him.
up on the screen, if we could pull him up from the gallery.
Sorry, Jeff.
I see his name.
Oh, I see him.
He's on mute. It looks like he's on mute.
Yeah.
I see him speaking, but I don't hear him.
Okay.
And
Bob?
can you hear me now?
Yeah, there you go.
I can hear you. Thank you.
Bob, even though you were sworn into the last meeting, I always re-swear witnesses. Please raise your right hand. Solemnly swear the testimony you're about to give this evening will be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Please state your name for the record and your affiliation with the applicant.
Robert Curley, and I'm the project manager that's been working with iStar for the Waterfront redevelopment.
Great.
Professional
Thank you.
engineer.
Thank you.
So does the board have any questions for Mr. Curley?
I just had one question. It's really just a clarification. In reviewing the minutes from the July 27th meeting, I noticed that Mr. Curley, you had said that DEP looks at all current regulations in their review. And I want to make sure that I understand correctly what Chris Jones was saying, which is that the compliance letter with CAFRA is actually compliance with 2004 stormwater regulations and 2004, he cited two, 2004 coastal zone management rules and 2004 stormwater rules. Is that right?
That is correct. I don't have Mr. Jones's email
Okay.
printed in front of me, but
Let me interject. I'm sorry for the interruption. Irina? Hello?
Yeah, we could, it's
I'm
been marked.
pulling it up. Just 1 second.
Oh, okay.
Yeah, we also have to enter those as exhibits as well.
Yeah.
I forgot to mention that too.
Enter both, yeah.
Yeah, we're gonna.
Just 1 second, just bear with me. Okay, you will see that on your screen now, the email from Mr. Jones.
Okay. How was that marked?
This is marked as Exhibit B1.
One for today? Okay.
Yes.
And that's fine, so that we have a reference point. And let's also mark the letter from Mr. Marizidi.
Yes, and that will be marked Exhibit B2.
Okay, thank you.
And you will see that on your screen in just a second as well. There you are.
Great, thanks.
Do you want me to leave the DEP letter up?
Alexa, you want the letter up? So
No, I was just whether or not it was meeting current regulations or was it 2004 regulations.
Okay.
And it's more just an interpretation if I'm reading that correctly.
Okay.
I believe Mr. Jones's email references the original approval that was issued for the project, and that this particular site complies with the original approval.
Okay. That's the only thing I wanted for the record, just because previously it was stated that it meets all current regulations. But I do not believe that, I believe that the regulations have been updated since 2004, but it doesn't affect the CAFRA permit at all. I just want you to know that it meets 2004 regulations cited, those two citations.
Thanks, Alexis.
And then the one other question actually that I had was about the second exhibit. And it's again that I want to make sure that I'm reading it correctly about jurisdiction. I believe they're saying is because stormwater falls under Chapter 30 of the Land Development Municipal Code that we don't have jurisdiction because of the Waterfront Redevelopment Agreement, but not overall that the planning board has jurisdiction over everything in Chapter 30, but
Right.
it's because of the Waterfront Redevelopment Agreement.
Correct. It's specific for the Waterfront redevelopment
So
area.
that was the only other point of clarification. I want to make sure, honestly, that I was reading it correctly because I read it like 10 times and I just want to make sure I got it right.
Sure.
Waterfront redevelopment plan
Right.
supersedes
That's correct.
the other ordinance. It's that straightforward. Yeah.
Okay.
Right, but it's very specific and limited to the waterfront redevelopment area.
Yes.
Otherwise,
Understood.
planning board powers would remain.
Right.
Yes, absolutely.
Okay.
If we
And I
were
just
not
wanted
in
that
the,
kind of clarification too.
yeah, if we weren't in the WRA and this weren't a major project, or this were a major project, it wouldn't even be a discussion. Planning board could do what it had to do under the regular ordinances.
Okay. Thank you. Those were just the two things I just wanted clarified for the record.
Okay.
And just to note on your first point, if I could just add to that in the context of the review, yes, DEP is reviewing it in the context of 2004 because that's when the CAFRA permit was issued in the context of those regulations. But DEP has the right to review it, and we comply with the current DEP regulations. And so that's something where we've had in connection with other projects, DEP come back with, additional requirements specific to sites. And so, in connection with this application, the statement that they were making is that the applicant conforms to the requirements set forth under the 2004 CAFRA permit because that's when the parameters were set, but it doesn't mean that it's not being reviewed or being considered in the context of current regulations.
That's good to know. Is there any other questions from the board? Then we'll open it up to the public. Are there anyone, Irina?
Jim Henry's trying to get our attention. You're muted, Jim.
Okay.
There you go.
At the last hearing, we were given another site plan. Which is the one, that was the third one. What site plan are we actually reviewing now? Which is the one As I recall, the one we were given for last meeting showed some on-site detention facilities for the storm runoff. Is that now the site plan we're looking at, or are we looking at the prior one?
The prior one.
Okay, that's the one that has the 4-foot sidewalk to the east of the fence, a fence, planting area, and then another sidewalk within the fence?
Yes, so there are three site plan applications that were submitted. Our original site plan, which showed the public path in its original configuration. There was a second site plan which showed a change that would need to be made to the path to the extent that it were to be made public. And then the third site plan showed a change that was in contemplation of us being required at the local level to additional stormwater mitigation. But in light of the jurisdictional issue being resolved, that's no longer, something that's being considered.
Okay, so now we're back to the amended site plan, which is the second one that was submitted. Is that correct?
Or the first. It depends upon the board's position ultimately with respect to the public path. So you have the original site plan, which shows the path as it was originally proposed as a private pathway. You have a secondary plan for your consideration where the applicant had agreed that they would make the path public. It would look as shown on that revised site plan, but that was only in the event that the board was willing to agree and the applicant would agree to a condition that the city assume full liability, and that to the extent that they did not, then the applicant would have the right to build the path as it's shown on the original site plan configuration. So that's the distinction.
Thank you.
Sure.
Okay, Irene, is there any public questions for Mr. Curley?
Yes, I show one hand raised. It's phone number ending in 3350. Please go ahead and ask your question. Hello?
Yeah, Ernest. Can you hear me?
Yes, we can hear you now.
Ernest McNolly, 400 Deal Lake Drive, apartment 5D, Asbury Park, New Jersey. So Mr. Curley is the expert witness I'm questioning, correct?
Yes.
Okay, and you're the engineer, and the big issue last time was about the difference between the water quality and the water quantity, and it seems like some things have happened in between the meetings, and it's now your position that this water quantity issue conforms to the 2004 water requirements for water handling in that site. Is that correct?
There was a clarification email that was supplied by the NJDEP that indicates that the application was reviewed and complies with the original CAFR approval issued in 2004.
Okay, I understand. So that's 16 years old, correct? Well, I don't want to ask that question. That's correct. 16 years ago. So now, is it your understanding in your area that where this water, increased water volume will be created, that there has been a tremendous increase in density as well as impermeability of land, so that if you apply the 2004 standard, which is now you have an email that says that's what's going to cause the approval based on 2004, I'm just trying to understand the relationship between the reality of where this water is going to go today with all the changes over 16 years in permeability, in density, and surrounding development. That, correct me if I'm wrong, did you say that the letter states that there's an ongoing investigation as to the water handling or movement pending? In other words, you didn't get it yet, but the email kind of said, we're going to reevaluate. Is that correct?
No, that's not correct.
No, that's not correct at all.
The email very clearly states that this application complies with the original CAFR approval.
That's okay, fine. But I think some board members and myself are asking, how does that relate to the updated reality of where we are now? And I think
Mr.
someone
Mignoli,
said,
Mr. Mignoli,
What?
this is Rick Lambert. So let me reiterate what I said at the beginning of the meeting. The two emails that we received, one from the DEP, which really didn't give us any guidance as far as what our jurisdictional powers were to ask for additional mitigation measures. The second email was from the Redevelopment Council, who specifically gave his opinion that the planning board does not have parallel jurisdiction to impart any additional mitigation measures on the applicant. And the stormwater management plan that has been submitted by the applicant is in compliance with the CAFRA permit and meets all the requirements for the stormwater management for this development. Plain and simple.
okay, but my question is, I'm just going to reiterate, for the 2004 CAFRA and the standards of 2004, someone stated, I don't know who it was, and my question is, who stated that, I think it was the attorney for iStar, said that the current standards are in review. In other words, the volume of water, 50,000 cubic feet of water, is being considered by the EPA. That there was an email to that effect, which means that, okay, it meets 2000.
Ask the question. Don't keep going.
Okay,
Ask the question
okay.
and get
Okay,
an answer, and
so-
then go on. Get an answer to
Okay.
your question. Get an
Okay.
answer to your question.
Was it stated that the current conditions are being evaluated in addition to the approval that was given to the 2004, that they're looking at the water volume, not the quality, the water volume handling of the current conditions? Wasn't that how it was stated?
No.
No.
I don't think, no. I don't think that, I'm not sure
Well, the
what
question
you're
is,
referring
has to be
to.
to Mr. Curley.
I'm sorry.
And no, no, that wasn't stated by myself.
Okay.
Okay. Okay. Are you aware of any current reconsideration of water volume movement now being considered by the, I guess it's what, the EPA? Who did you appeal to?
It's the New Jersey Department of Environmental Protection.
Okay. So
That's the approving.
have you received any correspondence that, in addition to saying that you're in compliance with 2004, that the current situation is being reviewed?
No.
Okay, maybe my hearing is failing me then. Okay, so the other thing is, in terms of this project, you were kind of making references to the fact that the increase in impermeability was well within the existing systems and structure in place in that area, surrounding area, and that was it your testimony that the only bottleneck in the entire equation, apart from impermeability, is the size of the flume of Sunset Lake going into the ocean? Is that correct?
So it's Wesley Lake, and it's the.
I'm sorry. I meant Wesley. I am sorry.
And it is the outfall pipe that is the constriction that causes the flooding on Wesley Lake. That's correct.
Okay. And I think it was your testimony that if the project goes forward, that situation, it's unknown when and if it's going to be rectified. Wasn't that your testimony? In other words, there's no commitment to enlarge the flume or the outflow at this time that you're aware of. Is that correct?
Not to my knowledge, that's correct.
Okay. And I think I'm going to ask you that, has it been considered that while waiting for that, which is apparently, I think, did you testify that that's the main thing and the only thing that needs to make this all work? I think you did, didn't you?
For the drainage air basin within Wesley Lake, yes.
Right. And that means with the addition of the triangle development, that for this thing to be good to go with the decrease in permeability, with the increase in density, that once that enlarged flume or outflow is in place, there won't be any increased flooding on lake, which I think that was your testimony, correct?
We object to this line of questioning. We're discussing here specifics regarding Wesley Lake and what it takes to fix a lake. It has nothing to do with obligations required of this particular applicant in connection with this proposal. And we furthermore discussed jurisdiction of the board as it relates specifically to mitigation measures to be required of this applicant.
If the question goes, if you're alleging that the question goes beyond the scope of direct, then so state.
The question goes beyond the scope of direct.
Okay.
All right, but he was testifying about the outflow, wasn't he?
But that's not related to this development.
Well, to a limited degree, yes, he certainly did. Yes.
Thank you. So I don't understand how it's not part of direct.
It's if it goes beyond the scope of what he was asked, he didn't get into the entire specifics of what it's going to take to do this.
Correct.
He just talked about it as that's the remedy, and that's about what he spoke about, you know, in that general area.
Well, I agree, and he answered my questions, and he said, that's it, that's the bottleneck.
Okay.
So my question to him now is, forget the flume and the outflow. You build the project, right? Is the existing structure and system, right, are you ready to testify, or can you, that this impact on lake and the surrounding area will not exacerbate the problems that are flooding, let's say?
Again, objection to this line of questioning. I don't know what the bearing on this particular application is, because the applicant specifically shown through documentation obtained from the state as well as Redevelopment Council that applicant has met all of its stormwater obligations in connection with this site.
Right.
That's not my question. I know the obligations are met, but what I'm saying, are the circumstances going? I'm just asking on direct the engineer, in his, I don't know whether it's his opinion or testimony, that you build the project, it's not going to impact all the flooding problems of Lake Street. Is that your testimony? The way it is.
That's correct.
Okay. I don't have any other questions.
Thank you. Is there anyone else, Irina?
No, there is no one else. Thank you, Rick.
Before we go to Jennifer's closing, is there any other comments or questions from the board or our board professionals? Okay, thank you, Mr. Curley.
Ultimately, I do want to get Donna sworn, because I want to make sure that when we're all done, we know exactly what, we haven't lost sight of the forest through the trees, what the variances are and what the remaining exceptions are, so that I want to make sure that the board members understand what they're voting on.
Okay.
You know, in connection with the subdivision and then the site plan. Yeah, I just want to make sure we're all clear, that's all.
You want to go ahead and swear her in now?
Sure. Donna, please raise your right hand. Solemnly swear the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
I do.
And please state your name and affiliation with the board.
Donna Miller, board planner.
Okay. And I don't think we need to swear in Jason. If Jason, you think you need to be sworn, let me know. Okay.
That was a really affirmative movement.
Whatever. I get it.
Yeah, whatever.
So Jennifer, you're still up.
Hey, I'm sorry, John Moore here. I have a question as far as procedure.
Yes.
Before Jennifer closes, if we have like questions as far as what she's going to propose and what we're going to vote on, should we ask those questions now or after her closing?
I would say you'd ask them now, because that's what I was trying to get to. I want to make sure that you all understand what you're voting on.
Okay, cool. Like I have a question and concern. I'm going to go with what Jim Henry said. So the second plan, where they came back and said the sidewalk behind or going east of the development would be a 4-foot wide sidewalk, which to me is not wide enough. It should be a minimum of 5, which I think Mr. Manzel brought up for the public path. And the problem I also have with this, it says one of the conditions, if council says no as far as liability, then that takes all of our decisions off the board, which to me is total BS. Why should this board agree to something, then council say, no, we're not going to do it because of liability? So I think there should be some middle ground out there, like when another developer did the Asbury Hotel and said, we also want to rebuild Atlantic Park. And they said, and we'll rebuild it, same as putting in a sidewalk, and they'll maintain it for 10 years, not put the liability on the city. I mean, because again, you know, it's going to be a tough nut for the city to crack. Like, why should the city take on a financial burden as far as liability, as far as lawsuits and everything else for a private project? So I have definite problems with that part if that's going to be a part of this application. That's all I have.
So then is that for the board to determine if we want the first site plan or the second site plan?
Right, and just so you know, the original site plan is what's part of the record. The
Right.
change that would need to be made to make it a public path were simply drawn for the board's consideration, so that they weren't reflected in a plan. They were more drawn to show you what would happen as we had our, you know, our landscape architect and walk you through what the changes would have been.
So then I guess when we deliberate, we can determine at that time if we are happy with the original submission or if we want to consider the second submission? Is that how we do that?
Yes, but it's very important to that with respect to, you know, the path itself, the applicant was only willing agree to make it a public path to the extent that the city assumes liability. I understand the position of some of the board members, but the applicant was only willing agree to make it public upon that consideration. Otherwise, we're proposing the path as shown on the site plan that, you know, in front of this board for consideration. If it's to be a public path and opened up as a public means for individuals to come through the property, the only way it can be done was as shown, you know, during the testimony 2 or 3 hearings back, and on the condition of liability assumption by the city.
Can I ask one other question, Ms. Porter? This is Eric Gallipo, sorry to interrupt. So there is nothing that would stop somebody from entering the site on Heck Street or at the interface with the remainder lot, correct? And by wandering around on the inside of their site, of your site, they could find themselves on that non-public path. Is that correct?
They could.
Okay.
However, here
Okay,
you're proposing essentially a direct cut through in the center of the AP triangle lot.
I understand.
Okay, more again, and with all due respect, Ms. Porter, I totally disagree with you that the liability should be put on the city. And again, if that's a condition of this, that's like usurping the planning board, where like we're going to agree to something, but then it gets kicked back to the city council, and the city council can overrule the planning board. So it's like, it's kind of like a blackmail to me. We're like, okay, we'll do this, but if city council overturns it, like it's off the table. I think there's got to be some type of negotiations here where, again, it's not the first time it's been done. We've asked for like, okay, you maintain it for so many years and blah, blah, blah. And as far as like, we can figure out the term liability, because if somebody trips, they're going to sue everybody and anybody. But again, I just hate that type of phrase being thrown to the planning board. And then where, again, planning board tonight can say we're fine with it, but then it goes back to council in 2 weeks. We can say, hey, planning board, go to hell. We overruled you, and we're not going to do it.
We couldn't obligate the city to accept the city itself to accept that liability for that property. That would have to be something that the mayor and council would have to vote on. We don't have the power to tell the city that they're now responsible for the liability there. That's beyond the scope of our powers. In site plan review, we can't assess liability on the city for that. We would have to make anything we would do subject to approval by the mayor and council to accept.
Yeah, that's what I was going to ask. We could say, you know, if this is something that we favored, that we would like to see this if the city council agrees to.
We can do whatever recommendation we want, but it's still subject to the review of the governing body. We
That's
don't have
correct.
the power to impose that liability.
But
That's right.
the need for any path in that location is being necessitated by the very specific dimensions and geometry of the subdivision that you've proposed and the design that follows from that.
Well,
I mean, I
again,
agree
don't
with what you're
forget that's-
saying. It's just that the applicant has to understand that this board cannot impose.
And I'm not suggesting we can.
Right.
I'm just.
And we agree, which is why we proposed it as a private path due to the fact that there would be liability considerations to the extent that it were to be made open to the public. So the only way that we can agree to that is to the extent that it be conditioned upon that acceptance, which we fully recognize and understand would require city council review and approval. And, you know, it's for that reason that we went with a private path, or we can simply remove the path from consideration. It's not something that's required at all in connection with this site plan application. It was something that the applicant was proposing.
It's a recommendation of the mayor and council acting as the redevelopment authority with the TRC input. So we take those recommendations to heart.
So Ms.
It was a
Porter, again, I'm
recommendation,
sorry.
right, it was a recommendation based upon the showing of the path on the plan that it be made or considered being made public. So in order to do that, again, that attaches additional rights in connection with it becoming a public space as opposed to private space. You cannot obligate an applicant to take liability for a public improvement that's being requested of an applicant.
Well, there's a way
So
around.
more again. So all I'm asking for is like 50% of the pie. I'm not asking for 100% of the pie. I'm like, why can't there be a common ground where the applicant and the city works together to make it a common path where but all the liability doesn't fall on the city again. And I bring up the Atlantic Park project where the applicant did it and the applicant made all the repairs and the applicant agreed to maintain it for either 5 to 10 years. I can't remember how long. Same as they've done with many other projects.
Again, don't forget here that the applicant is also giving a 6,000 square foot lot, dedicating it to the city and maintaining it as a public park for the next 5 years as part of the subsequent developer agreement. That's another entire lot at the corner that's being given as a public improvement. And actually, with respect to that improvement, it's very clear under the subsequent developer agreement that the applicant agreed that we'll maintain it for 5 years, but then it's going to be dedicated to the city, and the city will then own that property. So the same considerations to the extent here would apply, where if to the extent that you're making it a public space by virtue of allowing it to be a public pathway of travel similar to a road, the applicant has to be in agreement in terms of the means by which that can be done, and the applicant is unwilling to agree in the context of liability. Perhaps there can be further discussions with city council when we go back regarding potentially maintenance, but when it comes to liability, that's absolutely where the applicant draws the line. And it should be taken into consideration in the whole of the site, and not forgetting about the park parcel and the fact that that also is a public open space that will be dedicated and is being given as part of this application.
But that park parcel is being given as its own separate lot. In the case of the path, you're asking the city to accept liability on private land. At some point, that remainder lot, I believe that's what we call it, the remainder lot, would be transferred as its own property. And that's not what would happen with this path. And
that's a good point, and that's leading to my question: is it possible that the applicant may consider amending the subdivision plan to make the public path kind of its own small right, essentially public right of way,
Dedicated right away.
Yeah. I mean, is that something that could be considered by the applicant?
But I think I've expressed my concern about the orientation of the buildings and the specific subdivision, the specific geometry of the subdivision necessitating buildings that are in these locations with these requirements. The orientation of the building is driving the need for a path. And that a path that either serves your own that serves your own residents. You need that path to serve your own residents. The public nature of it is caused by the arrangement of so many front doors facing a non-public area. And here we are fighting over whether or not this should be public or private, when should it be there at all? And is the subdivision again wagging the tail of the dog?
And again, we respectfully say no, that the site was laid out and designed is fully compliant in the context of how it's positioned on the site, fully compliant with the waterfront redevelopment plan in terms of the site layout as it relates specifically to how the development lots, the remainder lots are configured.
Jim Henry, I take issue with that statement. It certainly is not fully compliant with the waterfront redevelopment plan. Building 3 certainly does not comply.
With what aspect of the plan?
With the orientation of that building. You're having
no,
new front.
Then incorrect. It absolutely does comply, and there are absolutely no.
I take issue with that. If you,
However, remember, keep in mind, it's not just that, the plan. This concept was approved by the redevelopment agency. And they're the ones that have the power to approve the concept and the layout of the buildings. And in right or wrong, good taste, bad taste, whatever you want to say.
It's not up for our consideration.
It's a completed act.
Can I ask for clarity on that, though?
Any criticism that you make has to take that into consideration.
The site plan went, but the subdivision wasn't the decision of the redevelopment agency.
No, the layout of the buildings on.
Understood, but I just want to clarify because we do have jurisdiction over a subdivision.
That is correct.
That's correct.
Right, okay.
And I would suggest that the subdivision is driving the design of the buildings, and all this is doing is setting up for the rest of the site to be equally internally focused in one of the most active portions of our downtown and entertainment core.
Okay.
It's not, again, it's going to have a public open space at the corner, and we're willing to agree to, it's not that the applicant is saying, no, we're not going to have a public path. We're saying we will agree and will provide a public path directly in the center of the site at that edge. However, liability is a consideration. So that's the only make or break item for the applicant as far as they're concerned, or they will agree that they will install a path and it can be made public. You know, based upon further feedback, it could be made a public right of way subject to very specific deed restrictions to be put into place in connection with that parcel. That's something that would have to be worked out with city council. But the liability issue remains at the center of the core of any discussion on that.
But for reasons of geometry and for reasons of being located in a floodplain, it seems that the corner site has presented itself as an opportunity for you to create public space. And I think that is a wonderful thing. And I think all of us are deeply appreciative of that. However, in the sense of the subdivision, the waterfront redevelopment plan specifically gives, did, as you have stated, Ms. Porter, did vacate certain portions of the public right-of-way to make the blocks more hospitable to development. And so it's not true that this is the only possible subdivision that could have led to a positive impact on the public realm, the public right-of-way, and the engagement of the buildings with streets.
However, you have to analyze this in connection with the ordinances that apply to the subdivision.
Exactly. All three development lots to the in terms of complying with lot area configuration, they have to have a minimum 15,000 square feet minimum size. All three of the development lots upon which the 3 strings of townhouse buildings will sit comply. The only bulk variances that are even associated with this application, just to go back, because it's a critical point, 2 specifically relate to the public open space parcel only. It relates to lot frontage because we have to get 100 feet, and we are at 86, so there's a 14-foot difference, but that only applies to the park parcel, nothing else. And then the other relates specifically to the size of that parcel. The only other bulk variance for the entire project
Understood.
under review is the lot width on Heck Street for one of the development lots, because it's 98.6 rather than 100 feet long.
Understood.
And that will go away once the development lots are built out, because they will be remerged into one lot, so it will comply. So it's a temporary condition, and that's it. Those are the only bulk variances relating to our compliance with the Waterfront Redevelopment Plan, nothing else. Well, everything else in terms of the relief that we're seeking relates specifically to design criteria in terms of architecture, has nothing to do with
Which
our
I have not complained about.
Yeah, it has nothing to do with bulk or layout.
However, the Waterfront Redevelopment Plan does specifically say that one of the generators of activity is to have facades facing streets. And this is not the most characteristic type of development you see in an urban area. And so I think the supposition that the particular arrangement of the subdivided lots is necessitated by this parcel doesn't hold up.
Again, City Council and TRC, we have a resolution from City Council which specifically states that the plan has found to be in compliance with the Waterfront Redevelopment Plan.
They found it to be in compliance. It doesn't mean it's good design.
That's okay.
Ms. Porter, John Moore again. Going back to what Mike Manzel said and adding a little bit onto it. It's just, I totally agree. It meets the waterfront redevelopment design. I have no problem with the frontage. I have no problem with anything like that. Where we came up with this walkway through the east side of your project and everything, you're asking for it to be a private right-of-way owned still by you, but the city to take liability. Why not make it a public right-of-way, deed 10 feet, and we'll have a 5-foot sidewalk and 2.5 feet on each side, and deed it to the city, and then the city will be totally liable for it. I just can't see us like losing this project over a 5-foot sidewalk where you're asking for the city to be liable, unless I'm missing something, to be liable for a piece of property on privately owned land, which I can't think of any other piece of property in the city where the city takes liability on privately owned property. And somebody correct me if I'm wrong.
No, Mr. Moore, we can, on behalf of the applicant, we can agree to do that. We can agree to do that. We're not asking that. We're simply stating, you know, when it comes to liability, we're not disagreeing that we're unwilling to do what we've done in connection with the park here. To make it a public right-of-way, it would be subject to express deed restrictions. So we are willing to work with the city in connection with making that piece public, you know, both in ownership and with respect to liability, if that's what it takes. We're not opposed to that.
Fantastic. If that's part of the resolution, you just got my vote.
It would still be, we still have to make sure the city will accept it formally, but I get where you're making progress. I get where you're going, but yeah, okay. It would still be a subject to.
That's correct.
Condition, okay. All right, okay.
Okay, so do we have any more comments or concerns or questions before Ms. Porter does her summation?
Is Jim Henry again. Are we making comments or are we asking questions of Mr. Curley?
I think Mr. Curley was done, unless you have more questions for him.
We finished with that.
Okay, so we're making comments. We're not asking questions anymore.
Well, you're asking questions of the board attorney, of the applicant's attorney, to discuss things, and then when you're done,
okay,
you'll sum up, and then we'll get the public comment, and then you'll deliberate and vote.
Okay, well, let me ask the question then. Is the applicant making a representation that they will dedicate a right-of-way to the city for that sidewalk area running from Asbury Avenue to Cookman Avenue?
That there would essentially be two paths as shown during our testimony. There would be the small one running along the edge of the building 3 facing out, and then there would be the public pathway that would be dedicated in yes, the applicant would agree to that.
to clarify that, let's start with the easterly boundary of this particular project. You have an easterly property line. You have a 4-foot sidewalk going to the west, which Mr. Manzella had requested to be made 5 foot. I assume that request is going to be honored. Then you have a 6-foot fence. You have a planting area. You have a sidewalk in a grass area, and then you have another fence, and then you have a building number 3 that faces east, with the front door is facing east, correct?
I believe that's correct.
Do we have a picture? Do we have a
Okay.
plan that we could reference that would depict all this so everybody can see it pictorially?
So we had drawn this in the context of the existing site plan at the hearing, but it was drawn for purposes of illustration as to what could be offered.
Okay.
And it's my understanding now that you're going to dedicate a area along the easterly property line, including a sidewalk area, a sidewalk of 5 foot wide, and that's going to be dedicated to the city, correct?
Correct.
Okay. Just so I know what we're voting on.
Yeah, absolutely. I agree.
And just to in connection with the fences, you have a 6-foot board fence, which will now become the easterly property line of this particular development, correct?
That's correct.
Okay. And then you're going to have a planting area, you're going to have an internal sidewalk, another internal fence, and then the front yards of those buildings facing east.
Yeah, I believe that's correct. Yes.
Okay.
Because with the 6-foot fence, that would be the edge of the public aspect to it, and then all of the internal, as currently shown in the site plan, with the exception that there would be now that internal path. But you're exactly right. It would have plantings. It would have the 6-foot fence on one side, and then inside of the interior walkway, there would be the additional fencing for the units.
Let me ask you why that 6-foot fence is necessary. Why is it necessary?
Again, it's a point of separation that was, in contemplation in connection with
what you're doing here.
Means of security.
What you're doing here is you're making a fenced-in compound from this particular AP triangle site, and you're making it a fenced-in area with the only clear access is the roadway coming in from Heck Street. And the testimony that was presented before was that it was for security reasons. But what you're doing is you're making a fenced-in compound in an area where you're inviting the people to come together, not separate them. And the necessity for that kind of a fencing is beyond me. I mean, you have plantings, which will give you the same effect. And what you're doing is you're creating something that the city is fighting to get rid of. The city wants everything to be inclusive, not exclusive. And that fence makes everything exclusive. And as a matter of fact, it is certainly contrary to the master plan and the concepts of the master plan. So in that...
Again, we disagree. We've gone above and beyond in the context of looking at what public aspects of this project can be made, but that has to be taken into consideration in the balance of what is driving this project, why the applicant is bringing this project, and the need for these markets for these units at the end of the day to be marketable. The applicant itself is putting itself at financial risk in order to bring this product to ensure that at the end of the day, these units get sold or it's all for nothing. And so safety, security, and all of these factors have to be taken into consideration in the balance of achieving the needs of allowing and integrating the public aspects of the project as well as the private aspects of the project. We can't forget at the end of the day that there are going to be individuals, families living here, and we also have to respect their right to privacy, and that has to be taken into consideration in the balance. And that's all that we're saying here. We're willing to give the public path, we're willing to have the public park, but there, at the end of the day, there has to be some defining line. It can't simply be that the entire site is allowed, you know, to be created to have no means of separation. That's simply all we're asking for, is some separation between the public and the private while still allowing both ends to be served.
And how do you then justify having single-family units on streets that have yards in the front and rear of them? It just goes against what you just said. This is what you're ending up here with, is a gated community without the gate.
They have fences. No, they have fences.
It's a suburban typology in the middle of an urban center.
Well, you know, if this were Smoke Rise or, you know, Rossmore or Clearbrook or something like that, well, then you might have a gated community because that's what you're doing here. But in Asbury Park, you're trying to have something that's inclusive, not exclusive.
I agree with that. And if you look at the history in terms of all of the wonderful projects that have come forth since Asbury Partners took over in terms of being the master redeveloper in the city, they're meeting consumer demand. The units are being rented, they're being purchased, they're being utilized, and it has brought great amounts of people and activity to the city. So it is ultimately serving that public purpose. So to say it's not is false. It's simply false.
I beg to differ with you.
All right, well, we're not going to get anywhere.
I'm sorry, Jack.
No, it's okay. But you're not, both of you have stated your point very well. Everybody stated their position. I think we got to kind of move on. I would like to get Jason sworn in, though, if you don't mind. Jason, do you solemnly swear testimony about the giving this matter be the truth, the whole truth, and nothing but the truth?
I do.
Okay, my question to you is, assuming a resolution is offered, whether or not it's adopted is another matter, what would be the best way for us to handle how this right-of-way and dedication is going to look? I assume we would need some form of formal plan with the details that have been discussed, submitted to someone, perhaps you, make sure that it complies. And then that plan and that dedication itself has to be, the dedication has to be approved by the mayor and council, because we can't make them accept title to a piece of property unless they vote in favor of it. Excuse me.
Yeah, I guess it seems pretty simple because that public walkway is all the way on the eastern limit of this portion of the project. You know, maybe some discussion from the board about how wide they would like that public right of way. And then, you know, that'll give the applicant the ability to either have a straight walkway or straight walkway, depending on how much space they have. And then we would just need to see a revised subdivision plan for that, which should be pretty straightforward.
Okay, I got it. Yeah, I'm just looking at the mechanics, that's all. Whether the vote yay or nay is up to the board. I have no say about that.
It's going to change lot sizes. If that means anything to you.
Is it?
Yeah, if you take if you take that area out and make it public, you know, sometimes what I've seen in various towns around the state, and Donna can weigh in on this too, some towns will allow you to use the pre-dedication lot area in your zoning analysis. Others require you to use the post-dedication lot area. But I'm going to defer to Donna here. This is a planning matter on lot sizes and all that kind of stuff. It may not matter, but I figured I'd mention it.
So this is Donna, and ultimately it's kind of a moot point. The temporarily, because of the lot sizes they're proposing for the phasing, will be undersized, but ultimately once they reconsolidate, they'll have sufficient lot area, and we don't have setback requirements. So those buildings are fine the way they are, regardless if the property line or the right-of-way line ends up, you know, aligned with those fences, or, you know, however the physical structures end up configured between that, as you move east from the buildings.
So technically, I'm sorry, Don, are you finished? Okay, technically.
I'm going to do it anyway. Is there a reason that this right-of-way isn't on the adjoining remainder lot? I know we keep using remainder lot to describe the park lot, but is it 1.02? I had the plat up and then I closed it. So that it aligns with the existing sidewalk at Berg Street?
Yes, because throughout this entire application, it's the applicants always maintained, which is still true, that the lines were drawn based upon what size lots were needed in connection with the development of these 3 strings of townhomes, and that's what drove that lot line configuration. The remainder lot was never considered as part of this because that's reserved for future development. There's no intentions with respect to that, so it's always been preserved in that fashion, which is why we haven't touched upon putting any type of improvements on that lot because it's reserved for the future. There's no specific plan in place. We're working within the confines of what we found to be what was needed to do this development. And that's why we were working, inside those lines.
So my question is, because of the specific geometries we're talking about, is it more appropriate for that public cut-through right-of-way to connect Asbury Avenue to Cookman Avenue to be not on this development parcel, but on the adjoining development parcel?
Well, that raises an interesting question because that development parcel, when it's developed, will also come before the city for site plan approval, potentially for subdivision approval. So that would absolutely be the time when it would make sense for the board to impose that type of improvement. But here, it's being requested in connection with this application, which deals with a different portion of the site. And see, that's been one of our initial concerns. We're trying to squeeze everything into this development when we have the remainder of the lot that's coming in front of this board. Maybe now is not the time. You have that second bite at the apple. You have that ability to make that part of any, future consideration in connection with lot 102. So it begs the question, if we're going there, is it better suited to be something to be taken into consideration in the future when we develop lot 1.02? It's bigger, it has more area, it lines up exactly as your planner just indicated.
This is Mike Manzella. I think you're right, Ms. Porter. I think it is better to be considered with that development. I think the challenge that we have here is kind of twofold. One, we don't know what the subdivision is for the entire triangle block, right? So it's hard for us to even say what kind of width that public path should be because we don't know what's going to be on the other side of it. That's one point. And the other point is, I think the only reason we're talking about this, again, as Mr. Gallipo kind of mentioned, is because one of the buildings fronts on a walkway. So regardless, we had to talk about this walkway. I think that's the only reason it's gotten to this point.
Well, no, I'm sorry, Mr. Manzella, Don again. It was clear during the TRC process that there was a desire to make that connection. And that's why it says in the TRC memo that it should be a public walkway. Mm-hmm. It's, this kind of disconnect that we got between the TRC and the redevelopment agreement that now there's a gate and it's private and there are these concerns about, this equity versus the privacy and security concerns of future residents in the development.
And also, I just think it's a risky proposition for the board to assume that other development is going to happen within a certain time frame that would allow us that ability or authority. That remainder lot is partially in a flood zone. It has major insurance issues. There are a lot of things that could affect development of that light.
If I may, Donna, would if we get this right of way done now, reduces the size of the lot to the west, correct? It's actually on the lot to the west.
If it's done as an actual dedication of right of way, as
Yes.
opposed to a right of way easement,
Right.
yes, then it would take lot area away from that part of the resulting tract.
Would that result in additional
Right.
variances?
Ultimately, like right now, the plat is showing the townhouse development on 3 lots,
Okay.
3 lots, right? Which represent each of the buildings to be constructed, which will then be reconsolidated, which is a potential condition that we've indicated.
Okay. Now, by doing that, would that cause another variance on lot size for the lots to the west?
Well, again, it's, if you take the strict interpretation of the 3 lots that will result from the subdivision as requested, then let's see. So again, depending on where they draw those lines,
Yeah, I don't.
Jason may be better to answer that question, whether they'd be undersized or not.
Yeah, that's what I'm getting at. Well, I don't want to.
I don't think that they could be. The 2 lots that touch the eastern property line, one is 24,000 square feet and one is 31,000 square feet. The minimum lot size is 15,000 square feet. There's no way taking a 5-foot area away from those lots would reduce them in such a capacity to make them under the 15,000 minimum lot size
How
requirement.
about frontages?
Well, one is 117 feet, so if you take away 5, you're still at
You're still good.
112.
Okay.
And then the other one is, it's the same. It's the
Yeah, that 98.
Okay.
98.83 would just go in.
All right. I just wanted to make sure that by.
And the other side is 243. So
That's
if you
fine.
take off 5, you're still at 239 or
I just wanted to
238.
ensure that by creating the remedy, we don't close one door and open another. That's all.
No, it would
Okay,
not.
that's fine. Okay. So then, okay. All right. I get it. So then it could be done presently. There's no reason to put it off into the future because unless there's a good planning reason, which I don't know.
To Mr. Gallipo's point, this tract, the overall triangle, is envisioned to have been divided like one of 3 ways in the plan. And we're trying to jam everything we can because this is the first opportunity. And the developer, for lack of a better way of saying it, is sort of holding back on what the potential is for the remainder. So we want to have that access. And so I totally support the board wanting to have it now. Do what we can, just get it on there so that we have it, because we don't know what or when the future will bring us that access.
You talk about the right of way.
Right.
Yes, I agree.
From, good comprehensive planning standpoint, I want that to align with Berg Street right-of-way sidewalk. I want it to be a proper width so it's comfortable as a multi-use path and not something where we can't pass 2 people or a wheelchair or people with bikes. But it seems like we're not getting that chance to sort of design it and shred it and feel it out because that hasn't been made available to us.
Well, we're going to have to get to those details because we can't approve an unknown.
This 5-foot wide sidewalk jammed against.
That's why I was talking to Jason. That's why I was questioning Jason. We have to know what the details are going to be because we can't approve something that's an unknown. Obviously, we have to see what's going to be there, and the widths and the landscaping and this with all the details so that we know the sizes, we know the location. We have to know these things.
Yeah.
Right. And again, in the
Yes.
Right, but we drew the plan and we can agree to the parameters in terms of the width now, to hold up a vote.
No, I'm not looking to hold anything up. I'm saying that we would have to define that this evening to the satisfaction of the board and the applicant before we can approve it. That's all.
Agreed, and the applicant's absolutely willing to give a 5-foot pathway as a public dedication or public, right-of-way easement.
I don't think that's what they were discussing.
So this whole discussion is what I was getting at before about deciding how wide this is going to be for a straight path versus a meandering path. So if we, and this is just for the board's consideration, but if we do a 5-foot public or right-of-way dedication, you're going to have a straight shot with your sidewalk and the lot areas get reduced by a little bit. The plan I'm looking at, the one that I think that is being proposed here with the meandering sidewalk, just as a point of reference, I'm measuring it off the plan, and it meanders as far as about 20 feet off of the eastern property line. Just to give you a kind of a mental scale of what would accomplish that meandering sidewalk. I'm not saying it has to be 20. I'm saying it sounds like we're somewhere between 5 and 20. So that should either be discussed or presented. How's it going to be landscaped and treated and all that kind of stuff? You know, that's just consideration.
Question for you, Jason. When you're considering this right away, should you consider something wide enough to put utilities in there in the event that you need to cross over with a water line or a gas line or a underground electric line?
That would be something that would be reserved by the adjacent property owners in connection with reservation of rights to allow for utility connections and otherwise to the two surrounding lots. So that would be taken into consideration as in the context of being a reservation of rights by the existing property owner, as opposed to it being something where there would be the need to run it, you know, along the pathway.
Well, I think we have to defer to Jason as to what the width of a right-of-way to look at this type of thing to see what we might need in the future and in the near future.
I think for utilities, unless there's something that's identified right now, it's hard to imagine. You know, utility right-of-ways are one thing. You know, they'll have a width associated with them, but just for a public sidewalk, there's no standard for that I'm aware of. You know, 5 feet could conceivably do it if you just had a straight shot. You know, if you had a standard 4-foot sidewalk and the public right-of-way is 5 feet wide, you've got 6 inches on either side for however it's going to be treated, hedgerow, fence, not, you know, something like that. But in terms of utilities, it's hard to imagine what for public infrastructure would be required in that area if something wasn't identified.
Hey, Moore here again. I apologize. I think it was 2 meetings ago. And Jason, you're looking at pictures. I can't see these pictures you're looking at. But 2 meetings ago, they put up the pictures. Mr. I can't think of his name, made the presentation. Yep. And he made the presentation, and it was a straight away shot. It wasn't curving that I remember. And it was just a question like, can it be 5 instead of 4? And the only question I had is about the liability. So to me, the 4 has been increased to 5. The liability has been solved. So I don't know what the problem is. I'm missing something.
No. And Mr. Moore, Mayor Moore, we 100% agree and are willing to do everything that you just stated. And that's essentially the applicant's position, that we're willing to give 5 feet. We're willing to do it as a dedication. You know, it comes with the liability that we discussed, and that's it.
And I believe that's all we wanted 2 meetings ago. So I think that's been forgotten about just because these meetings keep on drawing on and on and on. So I apologize if I made it more confusing, but what you're proposing right now is what I wanted 2 meetings ago. So again, I'm happy. Thank you.
So this is Mike Manzel again. My only concern is, I agree that satisfies a lot of what the board, I think, is looking for. My only concern is perhaps we should wait when lot 1.02 develops, because 1, it may be able to align better with Berg Street and that crosswalk that's there. And 2, again, we don't know what the development on 1.02 is going to look like. And the last thing we would really want is a 5-foot sidewalk that's surrounded on both sides right up to the concrete by a 6-foot fence. I don't think that would serve the public purpose either.
What if it's never developed, Mike?
I totally agree. I mean, you're talking about 10 years down the road.
Yeah.
None of us will be on this planning board. So, I mean, we're talking about it's a floodplain, it's this, it's that. We're talking about, like, you know, give me my crystal ball and give me the pick 6 numbers tonight, guys, and I'll be very happy.
This is Jen Souter. sorry, one thought about that too is that the 6 foot, because I had the same concern that Mike just raised about envisioning this with 6 feet fence on both sides. Of course, we don't know that would be the case, but the 6 foot fence on the current side, we do still have an opportunity to discuss further. I mean, I think that to me, the issues that Mr. Henry brought up are really very real, regardless of which side you're on and which side of the fence you're on. When you have a 6 foot, regardless of whether it's east or west, 6 foot fence, it creates that condition that I don't think it does satisfy all things that were discussed 2 meetings ago yet.
Jennifer, this is Rick Lambert. Do the properties that face Heck Street, do they have 6 foot fences in front of their properties?
Again, the fence is, hold on, let me look back to our plan.
I don't believe 6 foot fences are allowed in front yards. I think the maximum height is
I think 4.
4. Okay.
Can we put this issue to bed if the applicant is willing to agree to drop the fence to 42 inches along the eastern side? That's as far as the applicant is essentially willing to go. I mean, on this topic, we're talking about something that's not required in connection with this application. We're willing to do the dedication. We're willing to do 5 feet. And we can drop the 6 foot fence to 42 inches, but that's all that we're willing, you know, we're at the end of in terms of what we're willing to offer.
Just for a suggestion, Jim Henry, for a suggestion concerning the 6 foot fence on the easterly boundary line in that area, how about instead of making it a continuous fence, that you interspace it with plantings so that you have, I don't know, 35 feet of fence and then plantings, and then another 50 feet down the line, you put another section of fence up so that you don't have a continuous, but you have your plantings making the remainder of your fence.
For security and marketability, we prefer to have the continuity of the fence, but we are willing to reduce the height to the extent that is a separation issue.
More again, I think it's a fair compromise, and I'm going to tell you something. I live at 1407 4th, and I have a fence around my yard, and part of it is for security. And I don't know how many other of you 9 have a house or had a house and had a fence around it, quite a few of you. So how you're saying it's an east-west divide and not security just blows my mind away.
I consider it a good compromise, a lower.
I think it's, yeah, I agree.
Me too.
Okay, we made progress. So are we ready for your summation?
I have one more question. Sorry. So the one other thing that I think we never clarified is we understand that the park is going to be dedicated and it's public space, but we've only seen representative drawings of it. So I would love to know what the process is, and will the public, because it will be a public say, have any say in what the final design is? How are we approving it without a final design of that park?
So it will be a public process. So essentially, under the subsequent developer agreement, we agreed that we would make that park parcel public open space. And so essentially what the subsequent developer agreement provides, and actually it's one of the exhibits that's been admitted into evidence, and there are excerpts that are highlighted specifically that deal with each and every provision dealing with the park as to how it's to be constructed, what the plans will, are to be approved, who's approving the plans, all of that. So essentially, just to summarize it, the park will be designed, landscaped, and agreed upon by and for City Council. So essentially, as part of our process, we must present landscaping plans showing the design of that park for review and approval by city council. So that process, that city council review process, will be a public process. So there will be the ability for there to be public input in that process when that determination is being made. In connection with, you know, when it's to be built, it's required to be constructed and completed prior to the issuance of the certificate of occupancy for the first string. So it will need to be in place long before the townhouses are ever complete. So when the first townhouse is completed, the park will be in place and it's fixed in that time. So it will be designed once we move forward in the post-approval process, assuming we get there, obviously. And that will occur over the course of the next several months as, you know, we move into the building process for the first string, and then it will be completed in connection with that. And what we were trying to do to show the board for purposes of showing the site orientation as it sits along Cookman is to give you a sense of what it may look like, because obviously we couldn't show you what it will look like because it's subject to review and approval by city council. So that's why we did it that way.
Okay, well then I would just encourage, and this is probably more for city council, I would encourage making that as public and transparent a process as possible. You know, that's really the best way to get public buy-in for a public park, which ultimately all of us will be part of.
More here again. I don't know if it's legal or what it is, but it's common sense. I would have no problem being part of the resolution saying we'll do the same thing as we did with the boardwalk. We'll have a public charrette and let the public design it. You guys got better taste than I do, so I mean, why should council do it? So I have no problem with Jennifer saying it's up to council, but part of tonight's resolution saying, and I know Yvonne's on here, so we'll have 2 votes at council saying like it'll be a public participation. We'll do a charrette.
That would be great. Thank you.
We can't require that because we don't have the power to impose that onto the mayor and council. But if the councilwoman and the mayor are making the statement on record that that's the way it will be, then when it gets to that point, that's the way it should be.
And I totally agree with John. And this is the process that worked very well for the North End Boardwalk. And I think having the buy-in from the community will make it a popular place and a place that people can accept. So, yes.
Okay.
Thank you, council members.
Yeah, I mean, I can craft a recommendation in the conditions but I can't make it a mandatory thing on how they should conduct their hearing. But you've got the representations of the councilwoman, so we'll make a recommendation consistent with that, if that's acceptable to you, Alexis.
All right, before we go on to the summation, just real quick, I want to clarify what we came to decision on in terms of the width of the dedicated public right-of-way. Is it just 5 feet, or are we going to have a little grass strip next between the fence and the sidewalk?
We had agreed to 5 feet.
Okay.
All right. So we're ready to move on to the next phase of this. Okay, Ms. Porter, you ready to give your summation?
Sure. So over the course of the past 3 months, you've heard extensive testimony in support of AP Triangle's applications for major subdivision and preliminary and final site plan approval. At the first meeting back in May, you heard from our site engineer as well as our planner regarding the major subdivision to merge the 19 existing lots, which comprise the AP Triangle lot, and to re-subdivide that property into 5 lots, consisting of 3 development lots for the 3 strings of townhouse buildings, 1 remainder lot for the public open space, and 1 remainder lot for future development, which is unknown at this time. We provided detail on the 3 minor bulk variances required in connection with the subdivision. 1 to permit 98.6 feet of frontage along Heck instead of the 100 feet required, which is literally a 1.5-foot variance, which will go away once the development lots are merged after construction of the 3rd and final string. We also discussed the 2 minor bulk variances for frontage and lot width for the public open space lot, which, as we testified, is not going to be used for vertical construction. It will be dedicated to the city pursuant to the terms of the subsequent developer agreement, and it will be constructed prior to receipt of a certificate of occupancy for the first string of townhouse buildings. We further provided testimony that the park is a permitted use. It's permitted as of right under the plan, but it's not required by the Waterfront Redevelopment Plan or the development project, but rather is being offered as a bonus by the developer to the city as an opportunity so that we can all create something special at the corner. At the June meeting, we had extensive testimony from the architect and the site engineer on the site plan application for the proposed townhome project. We discussed the design of the buildings, the orientation of the buildings, and the architectural features, and why the overall layout of the site, as previously approved by TRC and City Council, was in compliance with the intent and spirit of the plan, and that the minor design waivers were in keeping with the waivers granted for other projects in the waterfront redevelopment area and were reflective of the style consumers want as shown by market demand. In particular attention was focused on the path, on the AC units, and specific discussion on stormwater issues. At our first meeting in July, we put forth our landscape architect to discuss our extensive landscaping plan and planning testimony. We also addressed at that meeting that we would agree to make the path public so long as any condition regarding the path would indicate that such an agreement was only in the event that the city assumed full liability. And we've obviously discussed that in full definition this evening, subject to the further agreement that the path would be 5 foot wide, dedicated to the city, and attached with that would be the condition with respect to liability assumption. The discussion regarding the stormwater jurisdictional issue was the only topic that was discussed at our second meeting in July. We provided additional testimony at that meeting from Robert Curley on behalf of the master developer to shed light on some of the improvements that have been completed and the controlling documents regarding stormwater in the waterfront redevelopment area. It was ultimately agreed upon at that meeting that we would seek to meet with DEP and request a determination regarding local jurisdiction over stormwater issues from Redevelopment Council. DEP issued an email response on August 5th, which is part of the exhibits referenced this evening by the city, that it could not render an opinion as to whether the board had jurisdiction, as that was a local determination, but that the applicant had done everything it was required to do in accordance with the CAFRA permit. This afternoon, we received a determination from the city's redevelopment council that found that the board does not have jurisdiction over stormwater issues in connection with the site plan application because that jurisdiction is governed exclusively by the redevelopment plan documents and consistent in connection with the requirements set forth under the CAFRA permit as it relates specifically to those redevelopment documents. We believe we have sufficiently demonstrated that the applicants for subdivision and site plan review should be granted and that the minor bulk variances and design waivers are justified. Each and every issue raised by the board has been addressed, and for that reason, we respectfully request that the board vote in favor of AP Triangle's applications this evening.
Okay, thank you.
I just have one question. Did we mention that the air conditioning units are definitely going to be moved from the front yard to the roof?
The applicant, yes.
All right, thank you.
Okay, can I get any kind of a motion from the board or?
Mr. Chairman, before we open it up to the public, can we take a 5-minute
that's right.
break?
Take a 5-minute break?
Please. Three would.
Do I need to get a motion for that?
Motion for a break.
Second. 5 minutes, that's all.
Okay, motion.
And a second for Jim Henry.
Okay.
Thank you. All in favor for a break?
Aye.
Aye.
Thank you, everyone. This old guy appreciates it. Thank you.
Welcome to the club, Jack.
I got it. Thank you. Alexis, are the restaurants in New Hampshire closed for indoor dining like they are here?
No, they allow indoor dining, but I have not dined indoors since I've been here.
Okay.
So, but I believe with obviously the social distancing rules, but they are allowed to be open.
Okay.
Yeah.
Thanks.
New Hampshire, though, has a very low incidence
Yeah,
cases.
sure.
Vermont's the lowest, then New Hampshire. Maine's pretty low.
Yeah, a lot of it has to do with population densities, you know.
Like I said, social distance is a way of life in New Hampshire.
Absolutely.
Permanently.
Absolutely. One of my best friends from college lives, he's in Hancock, but it takes 10 minutes to get to his house.
Yeah.
You know?
Yeah.
Are we ready to reconvene?
You're right. Jack's here. Yes, thank you.
Does
Okay,
Irene have to
do it.
take roll?
Yes, she does.
Okay, are we ready?
I think so.
All right, I will now take roll. Mayor John Moore,
Here.
Councilwoman Yvonne Clayton,
Here.
Michael Manzella,
Here.
Jim Henry,
Here.
Jennifer Souter,
Here.
Alexis Taylor,
Here.
Eric Gallipo,
Here.
Rick Lambert.
Here.
And that's it, thank you.
So before we deliberate, do we have to open up for public comment?
Yes.
Yes.
Yes. Public
Okay.
comment?
I move to open public comment.
Thank you.
Second.
All in favor?
Aye.
All right, and just for the public to remember, if you would like to make a public comment, please raise your hand by pressing the raise hand button on your computer or dialing *9 on your telephone keypad.
And we're limiting to 3 minutes?
Yes. Okay, I have one hand raised, Mr. Magnoli. We're going to swear you in. Oh, hold on one second. I have two hands raised. Thank you.
Okay.
Mr. Magnoli, we're going to swear you in first, and then I'm going to start the clock, and then you may begin your comment. Okay, just 1 second. Go ahead and speak.
All right,
I'm
wait.
sorry, go ahead, Jack.
I need Ernest to unmute himself so I can have him take the oath. Excuse me.
Okay, there we go.
Okay, Mr. Mignoli.
Yes.
Yes, please raise your right
My
hand.
hand.
Okay,
What's up?
please, do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, please state your name again for the record and your address.
Ernest Mignoli, 400 Deal Lake Drive, Apartment 5D, Asbury Park, New Jersey.
Thank you.
Okay,
So,
Mr. Magnoli, go ahead. The timer has started.
So I've labored through listening for weeks and months, et cetera, et cetera, et cetera. And I have to say that I think in the larger picture of what's going on in Asbury Park, that this type of application and proceeding is very typical of what we're going to see. In other words, high density, lots of variances, lots of promises that the infrastructure can handle this literally out of control density. And in fact, it seems like what's ever needed to justify the ongoing strain on a city that really is not infrastructurally set up for this, no matter what you talk about, pollution, water pollution, ground swamping and flooding, power outages, garbage. It's sort of like forget everything and just keep building. And that seems to be the credo. And for those of us, I've lived here almost 15 years. And when I came in, it was like you got to see they're going to build the Esperanza and it's going to revive the city. And, I was really pleased when it went bankrupt and the one before it went bankrupt, because look what you get. You get these imposing, I don't know, I call them billionaire Godzilla buildings. They're like everywhere now. They block out the sun, the air. People can't move. The city is blocked from our own amenities. No one who lives west of Ocean Avenue in Asbury has any access anymore to anything. No parking, no nothing. We can't even get beach passes. And why? To accommodate a 2004 deal that was made that literally gave Asbury Park away for a penny on $10 bill, where the people who signed it, most of them got locked up and went to prison. And now we're beaten over the head with this thing that these developers are like the Padre Pios of the West. They're coming here to revitalize the city. Well, how? Crime is on the rise. The school system is failing worse than ever. There's crime, corruption, out of control, tax increases, flooding, pollution, prices are going out of sight, the proliferation of bars and clubs and alcohol establishments to the exclusion of normal things like a.
Thank you, Mr. Magnoli. Your time is up. Okay, and I have one more attendee. Ms. Kurzak, you are up. Jack, can you swear her in?
Yeah, she unmute her phone?
She's unmuted, yes.
Oh, okay. Barbara, please raise your right hand. Do you solemnly swear that the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
I do.
And please state your name and address for the board.
Barbara Krizak, 309 Lake Avenue.
Thank you.
I've listened to everything that's been presented, obviously, and I appreciate everything that's happened here regarding the stormwater management, and understanding that there are a couple of things that I'm a little disappointed. I'm hoping towards the future that we can kind of look at these things where there should be a lot more more pervious services that are used by all of our developers to help us, whether or not there's an issue with the lakes or not, that I'm not seeing based on this testimony. The other thing that concerns me here is that there was a mention that on Cookman Avenue that the streetscape will be completed once the lot is developed, the remaining lot is developed. And from things that I've heard today, that's not looking really promising. So the Cookman streetscape will not be done. Just like, the Asbury has and Heck Street has, Cookman will not, as a result of statements that were made by the applicant. That I find disappointing because we really never know when it's actually going to happen. So those two items, pervious services, completion of streetscapes when there's development that happens on a particular lot. And obviously more concern about stormwater management, which we certainly have heard voluminous testimony about. But thank you, those are my only comments.
Thank you.
Thank you, Ms. Krizak. And let's just check if we have any other hands. I don't show anyone else. Thank you very much.
Okay, any discussion with the board, deliberation?
Move to close public comment, please.
Yeah.
Oh, I'm sorry.
Second.
Okay.
Thank you.
Irina, do we have well, you can do a voice vote.
For public comment,
Yeah, to close it. Yeah, you need
Yes,
you got a motion and a second.
I had a motion by Michael Manzella and a second by, Alexis Taylor. All in favor?
Aye.
Aye.
Thank you. Any opposed?
Okay.
All right, board, it's time for us to deliberate. Any discussion?
This is Jen Souter. I just wanted to make a quick follow-up comment. I hope make it quick regarding, because I think there may have been some kind of probably me, the way I was interpreting something or saying something, but the comments about the fence. So the 6-foot fence and the pathway, because my concern there was that if we are creating, being that we essentially are asking for, we collectively, a public right of way there, or a public access in some form. My concern was partially from the urban design perspective of having that if we're asking for it and it wasn't there, it's an add-on. And then there in the design that there was a 6-foot fence, and just having that concern of creating that kind of that feel of having a 6-foot fence up against a pathway. So that was the concern, but also that the fact that there are things that can be done without a 6-foot fence that still create a sense of privacy and security, and that the fence isn't always, as I appreciate Mayor Moore's comment, but the 6-foot fence is always not always the best way to actually create a sense of security, as we all know. So it wasn't, we were talking east-west, I was talking east-west side of the pathway, not east-west side of the city necessarily. But that there's ways when you do create that wall, it can actually create a worst case in terms of security. So I just wanted to, I wasn't totally sure where we ended up on that fence.
I agree with you, all the statements that you're making about it actually creating a less safe condition. I think they agreed to a 3.5-foot fence.
Yes.
42 inches.
Yes, that's my.
42.
Yes.
Okay, that's what I wanted to clarify, because I somehow missed part of that piece.
Is that the same size as the fence on the Heck Street side as well? It's also 42 inches? Or is that 48 inches?
It's 42.
42, okay.
And it's more, and when I made my statement, I said security. It's probably 20% security, but I'm going to say 80% privacy, where like, yes, I have a garden. Yes, I don't want people cutting through my yard and stealing my tomatoes that I work so hard to grow. So, and yes, I don't want people just like leering into my backyard. So again, I apologize for using the word security. It should have been security and privacy.
Anyone else on the board? I would just like to say that I think one of the issues that presented itself frequently was the orientation of the buildings. And that was something that I think should have been addressed early on in the process when they went before the Redevelopment Authority and the TRC, because I share some of the same feelings that Mr. Gallipo has about the orientation of the buildings. But, you know, we were presented with something that we had no say over that. So I just want to put that on the record that I think that should have been addressed early on. And, you know, our hands were tied with that. We really had no choice to make any significant recommendations related to the orientation of the buildings.
And I totally agree with Eric's thing about the tail wagging the dog. I think it's a bizarre way to have a separate subdivision application that's not part of the final subplan, but that's just the way that this application came through.
You know, I think I've railed on the orientation of the buildings, and I think that Rick has highlighted here that there's a process that we need to examine on how TRC and council, we could do this in collaboration so that by the time it gets here, there's a more of a consensus about what the goals of the project are and whether or not it's fully in, while it may be in compliance with the specifics of the master plan or the waterfront redevelopment plan, I really don't think it meets what we would accept as really great standards of public design. It creates a wonderful environment for the private side and a decent interface with the public, but it doesn't do all that we would hope for. And as we have been in this moment of reckoning about the importance of public space and the importance of inclusivity and the importance of environmental justice, all of those things cropped up for us in this moment, and we didn't have a lot of opportunity to influence that process.
I agree.
But Eric, I think part of what you need to understand with this particular process is that most of it happened even before it came to the TRC, because the master developer has to give approval to the subsequent developer, and they
I'm trying to blame
already come to an agreement on what's going to work when they come to us. So you know, I know it's not smooth, it's not easy, but
well, then I would advocate for even earlier involvement of the TRC and the planning board with the master developer and the subsequent developers to make sure that, you know, or to just consensus building starts at the very earliest portions of a project. And if every step along the way, we're going to say, oh, well, TRC didn't really get to decide. And then it shows up at council and council didn't really get to decide. And then who decided?
Yeah, because I think, you know, what happens is there was quite a bit of input from the public and the board had concerns. And it really just was kind of moot points. We didn't really have any say in anything. And so it really, I think it reflects poorly. It looks like we're just kind of here to put a stamp of approval on something and let it go through. And I just, you know, that's really very unsettling for me, because I feel like, you know, this is a pretty significant development and its implications and the impacts are going to be significant. And just feels like we're just kind of like, well, okay, go ahead.
And I do want to be clear that I do think that, you know, Mayor Moore made a very good point that there are things that should be let go of over time, you know, and I want to make sure that I don't have a huge issue with the architecture. I don't think the gray color of the building is going to be a problem, or whether or not this window is a punched window or that window is. It's literally the orientation of the buildings isn't really in the spirit of creating an engaged and connected public and private environment. And the problems that we're discussing around this path, while a 5-foot path with a 42-inch fence is good, it seems like crumbs on the side of what could have been a much better process around how well we consider public design.
Eric, just a comment on your comments, Jim Henry. The TRC recommended that Building 3 be oriented with its frontage on one of the streets, not on the interior lot. And that was one of the recommendations made by the TRC. And from what I understand from the mayor and council's submission to the planning board, they accepted the recommendations made by TRC. They didn't change those recommendations. So we do have that, the authority to change the orientation of that building. That's something that the board can do.
Jim? I'm looking at the memo from October 1st of 2019 with there were 8 recommendations.
There isn't one for.
There isn't one there for that at all. It's not in the recommendations.
The only place that I could find the recommendation is in the actual waterfront redevelopment plan itself, which says that one of the major generators of activity.
That's fine, but it's not in.
No, and I'm backing you up. That's the only place where I can find a specific recommendation for facades and streets having a relationship. But years and years and years and years of public design tell us that facades face streets. And, facades facing a really great public space is also something that can be a really great public benefit and a value generator on the private side as well. So I will rest my point that I do not agree with the fundamental premise of what we were handed, and that I hope in the future what we can have is a more integrated and collaborative process that allows us to build consensus across multiple jurisdictional issues that we have at the council and TRC and the planning board.
More here, let me just, I'm going to agree and disagree. TRC is well advertised and open to public. Council, as the redevelopment authority, this project was well advertised and open to the public. Some people that, I'm not talking about board members, but some planners and everybody else who talked about some exceptions tonight could have been part of that process. So, I mean, if from here on out, and we learn from mistakes, from here on out, if every planning board member, every professional wants to know when those meetings are, mayor and council will send them a special invitation so they don't say, oh, we didn't know this was happening, because we do not do anything in a vacuum. We're totally transparent. So, yeah, my little bit irked with some of the comments. Yeah, again, when this came before council and we listened to it and planners said it met all the qualifications, and we listened to our planners just as we listened to our planners tonight and everything else. So if everybody wants a special invitation, again, we learn from our mistakes. You'll all get a special invitation to all the public meetings that are well advertised.
Thank you, Mayor. Thank you. I mean, I think it does address that point, but I thank you for keeping us informed. I think it would be.
As board attorney, I got to kick in here. Sorry, I don't mean to prolong. Okay. As a footnote, TRC is created and has membership. There are members, planning board representatives there. There are planners there. There are, I don't remember the total composition of the TRC, but it was fairly well discussed when it was created to try and get a diversification and get the appropriate people that from different disciplines there. The only other thing is if you go to a TRC meeting and you all go up in unison, I don't want to have anybody claim that we've had a public meeting without proper notice. So be careful of that. But as far as what Eric is saying, yeah, I mean, the procedure should be used, whatever. And if the TRC needs to be tweaked or something, that's another story.
Yeah, Jack, to speak to that composition and attendance, I think I'm very pleased with the representation on the city side. And I know that our board chairman sits on that TRC. I think that what came up during this application is that for a long time, and it's a systemic problem, that no one from DEP or DCA shows up to those TRCs. And I
was shocked when I heard
avoided. Trust me, no one is more shocked than I am that the DEP and DCA doesn't show up. But I think we could have avoided a lot of the issues here had we had DEP or DCA representation, any state representation at that TRC. So I would just encourage, I imagine what's happened since they haven't shown up at 10 years is that it hasn't been assigned to anyone and no one even knows that they're supposed to go. But I think if a compelling letter came from the mayor and council saying, hey, we're facing these major issues of development. We really need DEP and DCA to fulfill their obligation as representatives on this TRC board. And direct it to the commissioner. I'm pretty sure you'll get someone there. And I think it would help a lot in the technical review.
I would support that.
Okay, great.
Yeah, and as another footnote, since I was here back then, I believe that the DEP and the state mandated that they have a seat on that board.
Right. And
It
I'm
wasn't
sure that
like the
person
city
has
said, "Hey,
retired.
come on down and tell us what to do."
And didn't.
They mandated that they were going to be a part of the process. So,
I'm sure. But I think it would really help to
oh, of course,
reinvigorate it.
okay, I'm done.
Jack, can you read conditions you have?
Yeah, well, first of all, we've got two applications here, not one application, even though one is interdependent on the other. First and foremost, for the subdivision, pretty straightforward analysis. I don't have any conditions for the subdivision. Okay. Site plan, I have one or two subdivision, and let's get Jason. Jason, you can unmute. Go ahead.
There is a change to the subdivision application if we're doing that public right away.
Okay.
That's all.
All right.
That's
One is address the public right away. Granting, address right away. Yeah, that's going to dovetail right into the planning, to the site plan resolution as well. Okay. Reducing size of lots. Okay. No, and then I'm sure the subdivision is going to be perfected by map versus deed. Jennifer, is that correct? Yeah, map compliance, law, map, yeah, that kind of stuff.
She's on mute.
Oh, Jennifer, you're on mute.
Sorry about that. Yes, that's correct. It's a major,
Yeah.
so it'll be done by map as opposed to by deed.
Yeah, and I have some standard conditions that go into every resolution in the waterfront redevelopment: compliance with CAFR permits, compliance with any outstanding conditions of CAFR permits that have not been met, and so on and so forth. You'll see them in all of them. There's 5 or 6 of them, but the more gutsy ones are the ones that are specific to an application.
Okay.
And that's pretty much what I have. If somebody has something else, I'll be happy to add it as a condition. If they want to make a motion and make
Yeah,
it.
I think the AC units being accommodated on the roof has to be.
That's site plan.
Yeah, site plan.
Yeah, we'll take that up on the site plan resolution.
Oh, we didn't get there yet. Got it.
Yeah, we've got to do, the way this works,
Oh, so we're doing the subdivision
works
first?
out, it's 2
Okay.
separate applications, not one, an A and B. It's 2 distinct.
Okay, so can I get a motion for the subdivision approval with the addition of the 5-foot public right-of-way dedication as a condition?
So moved. Mike Manzella.
Second, Don Clayton.
Thank you. I have a motion by Michael Manzella and a second by Councilwoman Clayton. I will now take a vote. Mayor John Moore,
Yes.
Councilwoman Yvonne Clayton,
Yes.
Michael Manzella,
Yes.
Jim Henry,
No.
Jennifer Souter,
Yes.
Alexis Taylor,
Yes.
Eric Gallipo,
No.
Rick Lambert,
Yes.
and oh, I'm sorry, that's all. I have
Motion
5
carries,
yeses
6
and 2 no.
affirmative, 2 negative.
Subdivision approved.
Okay, the next is the site plan. What conditions do you have for that?
Okay, obviously the right-of-way specifics that I'm going to need from the board, because it's going to be subject to the applicant submitting a plan showing these dimensions. I have it that it's going to be a 5-foot wide right-of-way and a 42-foot fence to the west.
42 inch.
I'm sorry?
42-inch foot.
42
fence.
inch.
Oh, did I
fence.
say foot?
Yes.
I'm in inch. I'm in inch. Yeah. No 42.
I draw the line. I draw the line.
That's very
Sorry
private.
about that. I need a 42-foot wall on the other side of Wesley Lake to contain the water. Okay. And air conditioning units, screening, and location to be moved.
Donna, you're on mute.
Yeah, Don, I can't hear you.
Sorry.
Okay. Any other specific conditions for the site plan? Recommendation, the Alexis recommendation, the council regarding the process for the park design. Okay.
If I might ask a question, sorry, with this 42 inch fence,
Yes.
is there going to be a 10-foot hedge planted 1 inch on the inside of it? You know, so it's kind of this question about like.
No, so the landscaping will be exactly in keeping with what's already shown there when it was being considered as a private path. It'll just be shifted over and slightly rearranged to accommodate the new path layout.
Can we make a recommendation for lower plantings to be located directly adjacent to the fence so that you can see around to avoid the canyon effect?
You make that part of your motion, whoever motion it is.
They voted against the subdivision.
Yeah, I know. I'm saying whoever makes the motion can make that a part of the motion.
Can I ask a question on this, since this is a condition of approval and we're looking at resolution compliance review here?
Yes.
We have the public right-of-way is going to be, the eastern side of the public right-of-way is going to be the eastern side of this project. It's going to be 5 feet wide, and there's going to be a 5-foot walkway in that 5-foot public right-of-way and a 42-inch fence on the eastern limit of this 5-foot sidewalk. And then what happens on the west side of the sidewalk? Is there
The fence is on the west side.
Yeah.
I think the fence is on the western side of the sidewalk.
Yeah, that's correct.
And nothing on the east?
No, it's open to the lot adjacent to it.
And no landscaping on the east side? That's a question mark. No landscape on the east side?
No landscape?
No, that's a different lot.
And what about all right, so we have the fence on the west side, and I heard Mr. Gallipo talking about some lower level landscaping. Are we doing anything with that?
I made a suggestion that the landscaping on the west side of the walkway adjacent to the fence should be lower to avoid a canyon effect. That's my suggestion.
The plantings will be on the west side of the fence.
That's correct.
Question, so there won't be any planting between the fence and the walkway?
It's not wide enough. The whole entire right of way is exactly 5 feet, and the walkway is 5 feet.
All right.
All the planting will be on the inside, on the western side of the fence.
Okay.
Until further development of the eastern side happens.
Does there need to be any specifics about the park, the dedicated land for the park? Does that need to be included?
I think it's
I already included the recommendation
Okay.
Alexis brought out and the comment, and that Yvonne and John agreed to.
Okay. So can we get a motion relative to this site plan approval?
Jack, one more thing. You're gonna have standard conditions in there, like compliance with our letter unless otherwise addressed.
Yes. Yeah, all the usual, engineering letters, the other 10 or 15 comments conditions that are usually thrown in. And of course, anything that is in Donna's report that's going to be changed around, if there was any change to any landscaping or anything like that, any of those amenities, that will also be thrown in. When I do this resolution, what I'm going to have to do is I'm going to have to go back and get the minutes, and I may even get the recording, because this is such a voluminous application, and we were all over the place with some very unique issues. I want to make sure that I go through the record to make sure that there's probably some things that we're missing that should be included.
Okay.
About findings of fact and things of that nature. You know, and of course I get the usual comments from both Jason and Donna, because we all work together on these resolutions. They're rather complex.
So Jack, when you finish the resolution, then you bring it back to us one more time and we vote on it again?
Oh yeah, I always send you the draft first.
Okay.
And then you know, I get comments from everyone, whoever's going to give them. We usually, something like this usually takes 2 to 3 editions.
Okay.
Finally get it refined down. When we get it real close, maybe when we get to the next to the last one, I send it to the applicant's attorney. I dare not send an applicant's attorney a raw resolution, because then they try to rewrite it for me. But that goes with the territory. 42 years of experience tells me you don't step in on that mine. You know, we also get their input, because we don't want to come in, do a resolution and realize we missed something and then have to come back to the drawing board for another meeting. I'm not interested in that kind of nonsense. So that's that. And from a technical point of view, typically if these were done together, which I'm still wondering why they weren't, as an A and B application, A and B part to this application. You know, you might say, well, since Eric and Jim voted against it, the subdivision, maybe they wouldn't be voting on the site plan, but I don't really think that's the way I'm going to rule. I'm going to rule that they can, because these are 2 distinct applications. And as long as they're going to give it a fair shake and not be biased or prejudge it, then by all means, they can participate in the vote.
Okay.
Unless we get some objection from Ms. Porter.
No.
No. Cool. Okay, with that, I'll be quiet.
I'll move to approve preliminary and final site plan approval for this application.
All right, subject to those conditions.
Subject to the conditions.
Okay.
Second.
Thank you. I have a motion by Michael Manzella and a second by Councilwoman Yvonne Clayton. I will now take vote. Mayor John Moore,
Yes.
Councilwoman Yvonne Clayton,
Yes.
Michael Manzella,
Yes.
Jim Henry,
No.
Jennifer Souter,
No.
Alexis Taylor.
Yes.
I'm sorry, was that a yes?
Yes.
Thank you. Eric Gallipo,
Can you come back to me? I guess you can.
Uh-uh.
I know. Did I prejudge? I'm voting, I have to take a second. I'm voting on the site plan.
That is correct, not the subdivision. You already voted on that.
I hate the site plan. No.
okay, I have a no. And Rick Lambert,
Yes.
thank you. I have 5 yeses and 3 nos.
Motion carries.
Site plan approved.
Great.
Yes.
We're done. That's it for that application.
Finally.
Thank you, board members.
Thank you for your patience and allowing us to really go through every aspect of this. So can I get a motion to adjourn?
Oh, God, yes. Move to adjourn.
Thank you. Can I get a second?
Mike Manzella.
Mike Gonzalez. Thank you. All in favor?
Aye.
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 Thank you. Meeting adjourned.
Thank you. Good night, everyone.
See
Good
you
night.
on
Good night.
September 14th.